Now that we've talked about the criminal trial process, including pre-trial and the criminal trial itself, we'll now talk about the step that immediately follows the criminal trial. If in fact a verdict of guilty had been reached, and that next step is sentencing and punishment. So in this particular lecture, we're going to begin just by providing a broad overview of sentencing and punishment, then talk about some of the goals and principles of sentencing within the context of criminal justice. We'll then talk about some of the factors that influence the decision-making process of sentencing judges. We'll then talk a bit about the actual options or forms of punishment with respect to sentencing, probation and imprisonment, conditional discharge, etc., etc. We will then give a bit of overview on some recent statistics on sentencing and punishment in Canada, and then we'll end up by talking about obviously one of the most extreme forms of punishment, capital punishment, and address some of the controversies around this and use it as a basis for you to critically analyze the form of capital punishment within the criminal justice system. So sentencing can be defined as the judicial determination of a legal sanction upon a person convicted of a criminal offense. As we talked about, sentencing is imposed by a sentencing judge in the context of a sentencing trial, which immediately follows the criminal trial. There are a number of principles that judges at the sentencing trial must follow. And this is actually codified in the criminal code. The sentence must fit the crime, must be fair and just, but at the same time it should serve as a deterrent to the convicted and to others. There are a range of options a sentencing judge can choose from with respect to the sentence meted out to the defendant. This includes probation, which is the most frequently assigned sentence, prison, fines, suspended sentence, conditional sentence, discharge. Imprisonment is seen to be as the last resort as far as sentencing is concerned. It's actually the least type of sentence that's imposed. Like all criminal justice actors, sentencing judges are empowered to exercise a wide range of discretion when imposing a sentence. They can take into consideration mitigating circumstances of a case, which tend to lessen a sentence. They can take into consideration aggravating circumstances, which tend to prolong a sentence. And what's very relevant to Canada at the current time is the introduction of mandatory minimum sentences, which basically curtails the judge's latitude. And this is very relevant to the ongoing debate we're having in this course about the Harper government's Bill C-10, the Safe Streets and Communities Act. There are a number of goals and principles of sentencing within the criminal justice system. In general, the fundamental purpose of sentencing is to contribute to the overall goal of the criminal justice system, which is to maintain order, maintain a certain level of social control. In fact, the principles of sentencing are spelled out in section 718 of the Criminal Code, which states, quote, "The fundamental purpose of sentencing is to contribute, along with crime prevention initiatives, the respect for the law and maintenance of a just, peaceful, and safe society by imposing just sanctions that have one or more of the following objectives." So some of these objectives are denunciation, so denouncing criminal behavior, unlawful conduct, punishment, ensuring that there's accountability of criminals within society, deterrence, so deter the offender from committing more crimes or to deter others within the general public from committing crimes, to prevent future crimes, whether it's through incarceration or deterrence, protection of society through the incapacitation and jailing of chronic offenders, rehabilitation of offenders, and the broader principle of justice. As we discussed throughout this course, justice is one of the defining principles of the Canadian criminal justice system. And in the context of sentencing, justice refers to the principle of the punishment fitting the crime, that the punishment is fair and just. And finally, one principle that tends to get forgotten is that there should be reparation or restitution, and that is to victims of the crime and to the communities that have been victimized or impacted and to society as a whole. So there are a number of factors that influence a decision made by a sentencing judge. First and foremost are the principles that are spelled out in section 718 of the Criminal Code. And this section states that a sentence has to be proportionate to the gravity of the offense and to the degree of responsibility of the offender. And in section 718.2, a court that imposes a sentence must take into consideration the following principles. First of all, a sentence should be similar to sentences imposed on similar offenders for similar offenses committed in similar circumstances. And this again is the principle of case law, where judges follow the decisions of other judges. A second important principle is that where consecutive sentences are imposed on the defendant, then the combined sentence should not be unduly long or harsh. A third principle is that the offender should not be deprived of liberty if less restrictive sanctions may be appropriate in the circumstances. In other words, what this means is that a prison sentence should really only be used as a last resort. Another important principle is that all available sanctions other than imprisonment that are reasonable in the circumstances should be considered for all offenders, with particular attention to the circumstances of Aboriginal offenders. So again, this is a principle that emphasizes imprisonment as the last resort, and particularly it addresses the circumstances of Aboriginal offenders. It recognizes the circumstances of Aboriginal communities and also the fact that Aboriginal offenders tend to be disproportionately represented in imprisonment. So judges are encouraged to look at alternatives for offenders, alternatives to imprisonment, and especially for Aboriginal offenders. So a judge may have a pre-sentence report prepared before the sentencing decision is made. The judge may consider information and recommendations contained in these reports that are specifically prepared for a sentencing hearing. A pre-sentence report may be prepared by a probation officer at the request of the judge, and this document contains information on the offender's life history as well as the details of the current offense and prior offenses. It generally concludes with an assessment of the offender's suitability for various sentencing options and may include a recommendation for a specific sentence. So a pre-sentence report generally is the context for the offender that will influence the decision of the judge. So while a criminal trial can't take into consideration previous offenses by the convicted offender, a sentencing judge can take that information into consideration. Victim impact statements have become quite common now in sentencing hearings. Section 722 of the Criminal Code provides that at the sentencing stage, a crime victim can submit to the court a victim impact statement explaining his or her own personal and emotional reaction to being victimized, any physical injuries caused by the victimization, and any financial impact of the victimization. There are no limitations on the kind of offenses for which a victim impact statement can be submitted. However, it's most commonly used for crimes committed against an individual, in particular violent crimes. A victim impact statement can be submitted to a judge, or it can be read at a sentencing trial by the victim. Now, finally, the sentencing judge takes into consideration a number of aggravating and mitigating factors with respect to the convicted offender. So mitigating factors basically help to lessen the severity of a sentence. So for example, Intoxication can actually be considered a mitigating factor. If someone was drunk and committed a crime while drunk, except for drinking and driving, then that can actually be considered a mitigating circumstance and may actually lessen a sentence. Any lack of premeditation, so if the crime was committed on a spur of a moment, being provoked into self-defense is a mitigating factor. Acting out of financial need rather than greed or profit is considered a mitigating factor. And then there's a number of circumstances or a number of characteristics of the offender that may be considered as mitigating circumstances, such as psychological problems, the age of the offender, being Aboriginal is a mitigating factor, the absence of any criminal record, or even addiction to alcohol and drugs. So all these mitigating factors can be taken into consideration by the judge when making a decision, and these mitigating factors serve to actually lessen a sentence. The sentencing judge can also take into consideration the good character of the offender, and also say a stable employment record, and any attempts at, say, treatment and rehabilitation. So all of these are mitigating factors and all can be taken into consideration by the sentencing judge. Now, the absolute opposite are aggravating circumstances. And aggravating circumstances are factors in a particular offense that can result in a more severe sentence than would normally be imposed. So aggravating circumstances include, for example, the use of a weapon, the prior convictions on the same offense, in particular sexual assault, the carrying out of a crime on behalf of a criminal organization. If it was drug trafficking, it was trafficking around a school, that can be an aggravating circumstance. So there's a number of other factors that a judge can take into consideration that will actually increase the sentence. So these are important. These are often articulated in the pre-sentencing report. The accused himself or herself can actually argue for mitigating circumstances because of certain conditions. The Crown Counsel can argue for aggravating circumstances. So there's a number of factors a judge can take into consideration that can lessen or increase the severity of a sentence. Finally, we should talk about mandatory minimum sentences again. As we've discussed throughout this course, sentencing judges are limited by certain offenses that can carry mandatory minimum sentences like murder or sexual assault. And as we've discussed, Bill C-10 introduced by the Conservative government introduces even more mandatory minimum sentences. So they're very controversial because it basically limits the discretion of the sentencing judge, and many call these minimum sentences unjust, especially for the offenses that the Harper government are including, such as growing more than 6 pot plants or being in possession of a firearm. And in fact, legal challenges have already been launched against some of the mandatory minimum sentences that have been introduced by the Harper government. But the important point in respect to sentencing judge decision making is that mandatory minimum sentences basically takes away the discretion of the sentencing judge. So we'll now turn our attention to some of the different sentencing options or forms of punishment that can be meted out to convicted offenders. And some of the ones that we'll touch on are probation, imprisonment, suspended sentence, fines, restitution, conditional sentence, as well as absolute and conditional discharge. The sentence that is most frequently handed out in Canadian sentencing hearings is probation. Probation basically means that the convicted offender is not incarcerated, they're not imprisoned. Instead, they are released into the community. However, it's important to note that the convicted offender is still serving a sentence. They are still under the supervision of the correctional system. It's simply that instead of serving a sentence in prison, they're serving a sentence in the community. Now, if one is going to serve a sentence in the community under conditions of probation, then there are often many different conditions set by a judge that the offender must comply with, which we'll talk about in the next slide. Within the context of being in the correctional system while in the community, the offender is supervised by a probation officer. The length of probation will generally depend on the type of offense committed, but the maximum length for probation as specified in the criminal code is 3 years, although there is what's called super probation, which is a maximum of 10 years for high-risk offenders. And the eligibility for probation is that it's generally used with minor offenses, summary offenses, and that the offender has no previous record. But again, it's very difficult to generalize when probation is used because it is used so frequently and with so many different types of offenders. And yes, it can even be used in the context of violent offenses, primarily if it's a first-time offense, and if the offender agrees to a wide range of conditions. So probation is the most frequently imposed sentence, and it's imposed on a wide range of offenses. So while the offender is released back in the community, they still are under the supervision of the correctional service. So I mentioned in the earlier slide that there are generally a number of conditions imposed upon those who have been given the sentence of probation. These conditions can be divided into two categories: compulsory conditions and optional conditions. All probation orders within Canada generally contain the following mandatory conditions. First, they have to keep the peace and be of good behavior. They have to appear before the court when required to do so by the court, and they have to report to a probation officer, and they also have to notify the court or the probation officer in advance of any change of name or address, and promptly notify the court or the probation officer of any change in employment or occupation. Now, there also may be a number of optional conditions that a sentencing judge imposes with respect to probation. This can include forcing the offender to abstain from owning or possessing or carrying a firearm, attending a treatment program, especially if alcohol or drug use has been a factor in the offense. They may be ordered to abstain from consuming alcohol or drug use, again, if drugs or alcohol was a factor in the offense. They generally have to stay in a particular jurisdiction. Often they can't leave the country. They're often asked to perform community service up to 240 hours. There may be conditions imposed that they have to stay away from, for example, children if it's a sexual offense, or women if it's a sexual offense. It's often imposed upon offender that they cannot associate with other known criminals. They have to stay away from other criminals. And they may also have to be gainfully employed or attend school. So these are options that a sentencing judge will impose when the sentence of probation is handed out. Another sentence that's fairly frequently handed out is an absolute or conditional discharge. What characterizes this sentence is that the offender can actually escape conviction and can actually escape having a criminal record. And so in the case of an absolute discharge, the judge grants an outright discharge of the conviction. In other words, no sentence is imposed, and because no sentence or no conviction, there is no criminal record. Now, a judge can also grant what's called a conditional discharge, and in this case, an offender has to satisfy certain conditions to receive the discharge. In other words, if they satisfy these conditions, they will not have a sentence or they will not have any criminal record. Now, if this condition is not satisfied, then the judge can revoke the conditional discharge, and then a sentence may be imposed. Absolute conditional discharge is basically limited to sentences of less than 2 years imprisonment, so summary offenses. So discharges like this are generally applied to cases where there are a number of mitigating circumstances with respect to the offender, and the judge feels that any kind of criminal records or sentence would be unduly harsh punishment. And a general offense that this applies to is possession of marijuana. You tend to see a lot of absolute and conditional discharges for individuals who may be found in possession of marijuana for personal use, not for trafficking, but for personal use. And it's again in line with society's general opinion that possession of small amounts of marijuana for personal use should not result in a criminal record or a criminal conviction, and many sentencing judges seem to reflect society's consensus on that issue. A fine is another form of punishment that can be handed out by a sentencing judge. And in fact, fines are the most frequently used sentencing option in Canada. Roughly 45% of all convicted adult offenders in Canada are fined. Any person convicted of an offense, except for an offense in which there's a minimum mandatory sentence, may receive a fine in addition to or instead of any other sanction imposed. So a court may fine an offender only if the court is satisfied the offender is able to pay the fine or work it off in a fine option program. For the least serious crime, in other words, summary conviction offenses, the maximum fine is $2,000. For more serious offenses, in other words, indictable offenses, there is actually no limit to the amount of the fine. The court will also normally impose what's called a victim fine surcharge, and this surcharge is an additional payment of up to 15% that's levied on top of the fine, and this money goes into a special victims fund to pay for programs for victims of crime. The court that fines an offender will make an order that clearly sets out the amount of the fine, the way the fine is to be paid, and the times by which the fine or proportion of a fine may be paid. So they'll set out a schedule on which fines should be paid. A number of options are available to assist in the collection of fines. So for example, the federal and provincial governments can refuse to issue or renew permits or driver's license until a fine is paid. In addition, the payment of fines can be enforced through civil courts. A similar type of punishment to fines is restitution, and it's similar in the sense that the convicted offender must make some type of financial payment as part of their punishment. So restitution is basically a payment made by an offender to the victim to cover expenses resulting from the offense, whether it's property loss, property damage, or personal injury. Restitution is also available to people acting in good faith who unknowingly become victims of criminal activity. So for example, a person may unknowingly purchase stolen property which is later confiscated by police, and they can receive some type of restitution. Or a person may unknowingly loan the offender money on the security of stolen property which is later returned to the lawful owner. Again, this indirect victim can receive restitution. So the amount of restitution is equal to the replacement value of the property in question. When someone is injured, the restitution may cover medical bills and lost income. And in the case of people acting in good faith who unknowingly become victims of crime, the amount of restitution may be equal to the amount paid for the stolen goods or the total amount of the outstanding loan secured by the stolen property. So crime victims basically make an application to the court for restitution, and there are standardized forms that victims can fill out, which are generally given to police, and the police pass this along to the Crown, and then the Crown hands this over to the units of usually the Department of Justice that deals with restitution. Another sentence that is frequently handed out is what's known as a conditional sentence. In general, a conditional sentence is a prison sentence that is served in the community. So an offender serving a conditional sentence is released into the community and must follow a set of rules imposed by the court for a specific period of time. Now, the primary objective of a conditional sentence is to provide an alternative to imprisonment, but if the offender who is on a conditional sentence fails to live up to these conditions, then the offender can be returned to court and they will be sentenced again by a sentencing judge, and this can actually include imprisonment. Conditional sentences are generally only applied to sentences of 2 years or less, so summary convictions. It's also important to make a distinction between a conditional sentence and probation because they both seem quite similar. They both involve a sense of the community. Although offenders on a conditional sentence are supervised in the community by probation officers, these offenders are not in fact on probation. The major difference is that probation is focused on the rehabilitation of the offender, while conditional sentences rely more on the principles of punitive justice, so punishment in particular. So this means that the conditions attached to a conditional sentence will generally be more onerous and more restrictive than the conditions attached to a probation order. And so the more onerous conditions generally mean more punishment or more of a punitive sentence. So some examples of the conditions attached to a conditional sentence that may not be attached to a probation is home confinement. Community conditional sentences can include conditions that an offender not leave their home. Electronic monitoring or electronic ankle bracelet is attached to the offender is not uncommon in a conditional sentence, although it's quite infrequently used in probation. So these are two examples of a couple conditions that can be attached to an offender serving a conditional sentence that generally aren't used for probation. So while both probation and a conditional sentence involve a offender being sentenced to the community, to serve their sentence in the community, the conditional sentence tends to be more punitive and the conditions more onerous than the offender who is serving probation. If we're going to talk about sentencing in Canada, then obviously we need to talk about imprisonment. Imprisonment is what we normally associate with punishment within the criminal justice system. It's obviously the most serious sentencing option available in Canada, considering that we no longer have capital punishment. So imprisonment pretty much constitutes the most serious sentencing option available. But imprisonment in Canada is considered to be the last resort and only to be used when less restrictive alternatives are inappropriate. Now, the courts are to consider all available sanctions other than imprisonment that are reasonable under the circumstances of the specific case. In other words, imprisonment should be seen as the last resort, and the criminal code itself, under section 718, encourages judges to use alternative sentences, to use alternative forms of punishment in lieu of imprisonment. And again, imprisonment should only be used when options for other sentences are not applicable or just in a particular case. Now, we talked about the difference between summary and indictable offenses. For the least serious offenses, called summary conviction offenses, the maximum term of incarceration that may be imposed is 6 months. For more serious offenses, called indictable offenses, the term of incarceration that may be imposed varies by the offense. So some offenses carry minimum incarceration terms, such as a second conviction for impaired driving. And the most serious penalty that can be imposed is life imprisonment. And life imprisonment is the mandatory penalty for first and second degree murder. Other offenses subject to life imprisonment include robbery, manslaughter, aggravated sexual assault, and breaking and entering. Whenever a offender is convicted on more than one charge, it's important to note the sentences imposed are to be served either concurrently or consecutively. Concurrent sentences are rolled into one time period and they are served simultaneously. So for example, an offender who is sentenced to 2 concurrent terms of imprisonment of 8 months each will serve 8 months, not 16. In contrast, consecutive sentences run separately, one after another. So in the same situation, if an offender who is sentenced to 2 consecutive terms of imprisonment of 8 months will serve 16 months and not 8 months if it's a concurrent sentence. Talk a bit about intermittent imprisonment. Section 732 of the Criminal Code allows the court, where it has imposed a term of imprisonment for 90 days or less, to order that the sentence be served intermittently. And basically this means that the court may direct that the offender serve his or her prison sentence on weekends. When the offender is not in custody, the offender must comply with the conditions set out in a probation order, which includes reporting to a probation officer. So we will talk more about imprisonment in the next lecture, in the next module, which deals with corrections. Another sentencing option that's newly available in Canada is the long-term offender designation, or long-term offender status, or LTOS. Basically, a sentence like this can be handed out to any person who meets the following criteria. They are serving a sentence of 2 or more years for a particular offense. There is a substantial risk that the offender will reoffend, and there is reasonable possibility of eventual control of risk of the offender in the community. So basically, an offender who has been designated an LTOS receives 2 years in prison, and then is followed up by 10 years supervision in the community. So this is what distinguishes a long-term offender status, is that the sentencing judge hands out at least a 2-year sentence. It can be more, but regardless of the sentence in prison, they are subject to 10 years supervision in the community. Another designation or sentencing option available in Canada is the dangerous offender designation. Section 753 of the Criminal Code describes those offenders who may be subject to a dangerous offender application by the Crown. And so in this section, any person convicted of a serious personal injury offense but not yet sentenced, who constitutes a danger to life, safety, or physical and mental well-being of others, may be subject to a dangerous offender application by the Crown. So a serious personal injury offense, as defined by Section 752 of the Criminal Code, is an offense involving violence or attempted violence which can or will inflict mental or physical injury on another. The offense may also be subject to a sentence of 10 or more years of imprisonment. So Section 752 also includes a list of sexual offenses deemed to be serious personal offenses. Now, the determination of dangerousness, or the dangerous offender status, is based on evidence including behavior associated with the present offense, displaying one of 3 possible results. There may be a pattern of unrestrained behavior that is likely to cause danger, a pattern of aggressive behavior with indifference as to the consequence of this behavior, or behavior that is such of brutal nature that ordinary standards of restraint will not control it. Alternatively, a person may be a dangerous offender if the offense for which the application is being made shows a failure on the person's part to control sexual impulses that is unlikely to result in harm to another. So Section 753 of the Criminal Code allows the court to sentence those offenders who receive the dangerous offender designation to an indefinite period of incarceration. Now, Section 761 of the Criminal Code provides for a parole eligibility review every 2 years after the first 7 years of incarceration have been served. So, in general, a dangerous offender status is applied to offenders that the court has deemed to be a uncontrolled risk to society. An individual whose crimes have been so heinous and who shows really no signs of rehabilitation, that the courts determine that they can actually be held in prison indefinitely. 2 of Canada's most infamous offenders, Paul Bernardo of Ontario, committed a number of sexual assaults in the 90s, and Clifford Olson, who sexually assaulted and murdered children in British Columbia, have been accorded the dangerous offender status, and Clifford Olson has died in prison, and Paul Bernardo is still in prison and probably will never see the light of day due to his offenses and due to the status, the danger offender status that has been imposed upon him. I'd like to turn our attention now to some recent statistics regarding sentencing in Canada, and this is from a 2012 Statistics Canada report on adult criminal court sentencing in Canada. In the fiscal year 2010-2011, probation was the most common sentence imposed in Canada, so 45% of all guilty cases included a probation order, and the median length of probation was 365 days. 33% of all guilty cases resulted in a sentence of custody in 2010 and 2011. In other words, 33% of all offenders who received a guilty verdict received some type of custodial sentence. And again, a custodial sentence can mean an imprisonment, but it can also mean probation, it can mean conditional sentence, it can mean a fine, any sentence that basically regards some type of punishment. Now, 86% of all custodial sentences were for 6 months or less. So they were summary conviction offenses, 86%. So the vast majority of custodial sentences involved a summary conviction offense. About 4% of all guilty cases resulted in a sentence to federal custody of 2 or more years. So these are generally indictable offenses. So as you can see, the vast majority of criminal convictions and criminal convictions that resulted in some type of sentence, custodial sentence, were summary offenses, while a very small minority, 4%, resulted in a sentence to a federal custody, so an indictable offense. I'd also like to briefly discuss what is called sentencing disparity. And what sentencing disparity basically means is when a similar crime does not receive a similar sentence. And so you often see disparity in sentencing among defendants. So the same offense, a different defendant, and a different penalty. And there is some justification for that given mitigating and aggravating circumstances. But there is also great controversy over the fact that you see disparity in sentences based on race. And what this means is that within Canada, African Canadians and Aboriginal Canadians tend to get longer sentences, even though the crime, the circumstances surrounding the crime, aggravating and mitigating circumstances surrounding the crime are similar to white offenders. In other words, African Canadians and Aboriginal Canadians tend to get longer sentences than white offenders who commit a crime, the same crime, under the same circumstances. So is this a question of disparity or discrimination? And this is a significant issue within the Canadian criminal justice system and the American criminal justice system and the British criminal justice system and the Australian criminal justice system. All these common law countries with multicultural populations and Aboriginal populations, at least in the case of Australia, the United States, and Canada, see great disparities in sentencing based on racial characteristics. And again, this is something that we have to critically analyze. Is the criminal justice system inherently discriminatory based on race? So this is a very important issue and one that we need to look at critically and ask whether or not people are being sentenced more harshly based on the color of their skin. The last issue I'd like to talk about in this particular lecture is the most severe form of sentencing and punishment, and that is capital punishment. We don't have capital punishment any longer in Canada. The last hanging in this country took place in 1961 in Toronto, but it actually wasn't until 1976 that capital punishment was officially eliminated from sentencing options in Canada. So it was essentially outlawed by federal parliament in 1976. Most Western countries have eliminated capital punishment, so throughout Europe, the UK, Canada, and the United States is the only major Western nation that still has a death penalty. And the death penalty can be imposed by the federal government, and it can actually also be imposed by states as well. Although many states in the US have now abolished capital punishment. So there's about 33 states in the U.S. that still allow capital punishment, and that also includes the U.S. military and the U.S. federal government. So about 33 states, as well as the U.S. and federal government. And the question in upcoming years will be which states actually move to abolish capital punishment, because certainly the trend in the U.S. Is the abolition of capital punishment, and it'll be interesting to see if the momentum to eliminate capital punishment in that country continues. Capital punishment is obviously an extremely contentious and extremely controversial form of punishment. And as someone who's studying criminal justice, it's one that you should seriously explore and consider. And some of the key questions that are raised in the context of capital punishment are the follows. First of all, does capital punishment actually serve as a deterrent? The argument is that capital punishment serves to deter individuals from committing murder. But if that's the case, then the United States would have, the fewest murders in the world, given the institution of capital punishment in many states. But in fact, it's not. It's one of the most violent countries in the Western world, and has one of the highest murder rates. What if the condemned is actually later found innocent? With respect to a life sentence can be commuted, and the wrongfully convicted can be returned to the community. But in the case of capital punishment, that's obviously not the case. So, and there's been a number of cases where individuals who have been hung or executed have been later found to be innocent. With respect to capital punishment, is it in fact barbaric? Is it immoral? Is it just? In other words, the old biblical expression of eye for an eye, can this actually serve as a basis for justice? Another important question about capital punishment is, does it discriminate? Does it discriminate based on race or on socioeconomic status? We certainly know that a disproportionate number of individuals executed in the United States are black and also are poor. Finally, the fundamental question of whether the state has the right to take someone's life is obviously quite pertinent. Does the state, does government have the right to kill somebody? So these are some very difficult questions, very moral questions that have no right or wrong answer, but are ones that I encourage you to explore and to weigh in with your own personal opinion.